Welcome to this explainer. Today we're unpacking a truly fascinating moment in legal history. We're talking about Constitutional Court Case CCT 2997. We're going all the way back to 1997, right into a high-stakes legal showdown, where the Western Cape's provincial constitution faced, well, the absolute ultimate test from South Africa's highest court. It's this incredible story of pushing boundaries, rapid-fire legislation, and figuring out the exact limits of regional power.
Okay, let's dive into this. On September 2, 1997, the Constitutional Court threw up a massive roadblock for the Western Cape. See, the province had actually passed its constitutional text earlier that year, on February 21st. But then, the National Court stepped right in and issued an order flat out declining to certify it. Just imagine the shockwaves. You've got a regional government trying to establish its foundational laws, only to be told by the highest authority in the land that their document just doesn't comply with the national framework.
Part 1, a constitutional roadblock, and that initial refusal to certify.
So, that refusal established some immediate tension, right? The province had to go straight back to the drawing board. But it is absolutely crucial to note that the court didn't just scrap the entire document. Not at all. The refusal to certify was only in respect of a limited number of provisions. Honestly, the vast majority of the province's work was perfectly fine. It was just a few specific, critical clauses that failed to meet the national standards laid out in the Constitution of the Republic of South Africa. But, as you can guess, even a few invalid provisions are enough to halt the entire certification process in its tracks. And this brilliantly illustrates the sheer speed and determination of the provincial legislature. Just think about the timeline for a second. The initial text was passed in February. The court strikes down those specific provisions on September 2nd, and then just 9 days later, on September 11th, an amended text is already passed. I mean, they scrambled, they debated, and they fixed the issues in literally 9 days. That is a blistering pace for constitutional law, practically light speed for government bureaucracy.
Part 2, Rules of the Game. Let's demystify exactly how they amended the law.
To really appreciate how they pulled this off, we need to understand the legal hurdles involved. Under Section 142 of the National Constitution, you can't just pass amendments with a simple majority. No way. It requires a 2/3 supermajority. So, despite a terrifying 9-day time crunch, the Western Cape legislature successfully secured that massive 67% political mandate on September 11th.
This builds directly into the next major legal hurdle, which is Section 143. This is really the heart of the matter because it dictates the contents of provincial constitutions. On one hand, you have the absolute non-negotiables. A provincial constitution must comply with the foundational values in Section 1 of the National Constitution and also with Chapter 3. However, on the flip side, we see where a province actually has autonomy. They are allowed to differ from the national constitution, but only in very, very specific areas.
So what are those exact areas? Well, the source text spells them out crystal clear. Under Section 143, a province can write its own rules regarding 3 things. Number 1, provincial legislative structures and procedures. Number 2, provincial executive structures and procedures. And number 3, the institution, role, authority, and status of a traditional monarch where that's applicable. Basically, the national constitution acts like a giant protective umbrella, but it deliberately gives regions the flexibility to tailor their own internal structures.
Part 3, Fixing the Text and the newly amended submission.
Once that rapid 2/3 majority was secured, the Speaker formally submitted the revised text right back to the Constitutional Court for certification under Section 144. But the Constitutional Court didn't just rubber stamp it. They opened the floor, formally affording an opportunity to the national government and any political party in the Western Cape to make representations. They essentially asked, hey, does anyone object to these new fixes? And the result? 0 objections. Absolutely no opposition was raised to the certification of this new text.
However, as we look a bit closer at the court's judgment, there is a totally fascinating loophole that emerged during this whole revision process. Let's define what's called Annexure A. According to the court's notes, the only alteration to the new text that wasn't actually caused by the September 2nd judgment was an amendment to Annexure A. This specific section deals with the composition of the provincial cabinet during a bridging period, basically the time between the coming into force of the provincial constitution and the second election for the provincial parliament. Now, what's really interesting about this is the exact quote from the judgment. The provincial cabinet is an executive structure. So why does that matter? Well, because as we established just a minute ago, executive structures enjoy special legal leeway under Section 143.
Because the provincial cabinet was legally classified as an executive structure, it triggered a very specific set of rules. Yes, the manner in which the cabinet is composed still had to comply with Section 1 values in Chapter 3, but crucially, and this is explicitly stated in the judgment, save for this, they do not have to be consistent with other provisions of the Constitution. This special status meant that Annexure A essentially bypassed the broader national requirements, perfectly satisfying the court's strict scrutiny. Talk about a brilliant legal maneuver.
Part 4. The final verdict on November 18, 1997.
When the final hearing took place, the rapid amendments were in, the supermajority was secured, and the tricky Annexure A was legally sound, counsel for the Speaker, J.J. Gauntlet, formally requested certification. And when the judgment came down that exact same day, guess how many dissenting judges there were? 0. Not a single one. After careful scrutiny, it was a completely unanimous decision by all members of the court that the provisions now complied.
So the crucial point is summarized perfectly in their decisive closing statement. They said, "We accordingly certify that the whole of the amended constitutional text of the Constitution of the Western Cape, 1997, as passed by the legislature of that province on 11 September 1997, complies with Section 143 of the Constitution." Boom! Just like that, in a matter of months, a massive constitutional crisis was navigated, negotiated, and fully legally resolved.
As we wrap up this explainer, I want to leave you with something to chew on. We literally just watched a regional government push for its own unique structure, get checked by a national court, and rapidly adapt to fit a shared legal framework without losing its granted autonomy. So how does this delicate balance of provincial autonomy and national oversight protect democracy today? It's an incredible example of how governments share power and how the rules of the game keep everything in check. Thanks for joining me on this deep dive, and keep asking those big questions.